And we are live. Good evening, everyone. We've been waiting on Nate the lawyer, but he seems to be a little bit delayed, so we decided to go right ahead. We
Yeah,
started talking about some stuff, and we figured we might as well do it live and in front of people.
yeah. Nate and I have had that sort of exchange a couple times where we'll have a conversation amongst ourselves, like, "Oh, we're giving up all this great content. Let's just go on the thing and share it with everybody."
Yeah. So the topic that we were discussing was I'll start by sharing my screen.
Ooh.
Right here. Woman convenes her own citizen grand jury. Now, Kurt, you told me about this case. I had no idea about this until about maybe 6 hours ago.
Yeah.
So tell me about it.
So there are a couple of states, I think five, in which there's a process for a citizen to convene their own grand jury, and up until this year, I think there was a process for a citizen to bring their own criminal charges in Virginia. So they could act as a private prosecutor. I think they got rid of that though this year in Virginia, or maybe last. But there are a couple states that have these weird idiosyncrasies where someone other than the sitting elected district attorney can bring charges or investigate a case. And the grand jury is kind of an investigative tool. So you can kind of think the functions of the grand jury have mostly been split into other elements. So they have a function to subpoena, they have a function to do investigations, they have a function to call witnesses, which are more of the idea of investigation rather than in terms of a trial, because there's no jury there, there's no defense lawyer there, it's just the prosecutor there in the vast majority of cases. So it's an investigative tool. And she was purportedly sexually assaulted. Apparently, it started out consensually, and at some point, less so. And the guy has pled guilty to aggravated battery, but not to rape. And so she is displeased with this and has brought her own grand jury together to, I'm not sure exactly what, but do something.
So you said that he already pled to aggravated battery, and that
Yeah,
was in that was obviously not in the case that she brought, but that was brought by the actual prosecution, right?
that's right. Yeah, the actual
When
sitting district attorney.
when was that? When did he plead that?
Ooh, I'd have to look it up to be honest. I don't know for sure.
Huh, interesting. I had no idea that this sort of procedure existed anywhere. But when I think about it, I mean, it's from Kansas state law from 1887. That sounds very much, I guess, in line with like westward expansion of the states as they're trying to sort of put together the laws and creating, various aspects of society while we were expanding towards the West Coast. But that's super interesting. Like I said, I had no idea that this existed. Did you know anything about this before this
I
case?
didn't know about the grand jury thing. I did not know that memo. No.
Okay. But yeah, it seems like one of the first things that we were talking about was that this seems like a situation where double jeopardy might
Right.
apply.
Yes. So the normal rule here, incidentally, is you have to charge all parts of a common criminal transaction. So you can't charge one part of a crime and then come back and charge a different part of the same crime. So the definition of criminal transaction changes slightly from jurisdiction to jurisdiction, but it's basically everything that's part of the contemporaneous sequence of events. So, to give an example, someone goes, robs the bank, they get into the car, they flee at high speeds, they get into an accident, there was a conspiracy involved in going to the bank to rob it. So all those things would be part of the common whole. So you can't charge part of it, come back and charge another part of it. That's not proper. So having been convicted already, that would mean that he can't be charged again. So it's one of the questions is, well, what is this body theoretically able to do that won't want to do? Now, I did come up with a partial answer to this question because since he's already been convicted and can't be convicted again, double jeopardy applies. And since double jeopardy applies, he has no Fifth Amendment privilege against self-incrimination because he can't incriminate himself anymore. It's not possible for him to incriminate himself because he has no criminal exposure. So that means, I suppose, that she can, and as I mentioned, the grand jury has the power to subpoena and force this guy to appear. So that means they can force him to appear and force him to answer questions. And any answer she gets, I don't know, but they can at least force him to ask questions. Like, I plead the fifth. No, you can't. You can't do that. You don't have a Fifth Amendment because you have no criminal exposure. So yeah.
Yeah, yeah. So, just here's a question here. Their own citizen grand jury, isn't that basically just a lynch mob?
No,
Well,
it's a legal process.
yeah, it is a legal process. In this particular case, as you said, it sounds like there's really no legal recourse or no legal result that can really come from this. However, there's a possible social consequence that he could have, I guess. I mean, it seems like so something that I've noticed just in practicing law is that most litigation seems to be very emotional. Like obviously there's money involved, there's in civil litigation there's damages. In this case obviously it's not a civil case, it's a criminal case, but excuse me. But these cases tend to be very emotional, right? I mean, half the time when somebody brings a case, they really just want the other person to tell them that they were right, that they were harmed, that they were hurt. And so in this kind of a case where she's gone out and petitioned for signatures to get her own citizen grand jury, I mean, I wouldn't be surprised if half of her motivation is just to see him sitting on the stand and saying, "I'm sorry, I hurt you, and I shouldn't have."
I guess. I mean, the prosecutor was able to get an aggravated battery, which only resulted in a 2-year probation sentence. So that's kind of disappointing. But the prosecutor had said, "Well, I didn't bring the charge because I couldn't prove it," and I believe that because in this particular instance, this event started off consensually. She admits that it started off consensually. And at some point during it, it became non-consensual and I think somewhat violent, which led to the aggravated battery charges because it became violent. So the issue, as always, is consent. And, well, it becomes he said, she said. Because we both admit it started off consensually. And, of course, you can withdraw consent at any time. But if they disagree, what evidence do you have that goes either way? Maybe the battery is subjective, but he thought, for whatever reason, he couldn't prove it. He didn't have enough evidence or it wasn't going to work. So at least based on the story, it's perfectly plausible that the prosecutor made a correct call. Prosecutors aren't supposed to bring cases they don't believe they can prove beyond a reasonable doubt.
Yeah.
So they're supposed to believe in their own head subjectively. They're supposed to believe in their own head subjectively, one, that you are in fact guilty, and two, that they can prove it beyond a reasonable doubt. Now, sometimes they don't get there, but they're supposed to believe that. Otherwise, it's a miscarriage of justice. And so it's a problem.
Yeah. But I don't know. This whole situation is really interesting.
And it's particularly interesting in the case of sexual assault because I can't think of any different charge, which is more subject to this different vantage point problem than sexual assault, because it's hard to imagine any other crime where people's perceptions could differ that much reasonably about what happened and what didn't happen from the two vantage points.
Yeah.
Now, of course, that isn't necessarily true in every case.
Yeah.
Maybe someone's lying about their perception. That's totally possible. But there's a lot of ambiguity. There's probably more ambiguity in this domain than I think any other charge is probably what I was going for there.
Yeah. And that's actually one of the most difficult aspects of this area of law and this particular charge in particular. That's great. No, but I remember thinking during law school when I was taking criminal law and we were going over the issue of rape and going over even just how you start as a baseline, like who has the burden to prove. Even that was a divisive conversation, and I think it still is today. Like a lot of people differ in terms of who has the burden. Is it her burden to prove that a rape happened, or is it his burden to disprove that a rape didn't happen?
Proving a negative is pretty hard.
Right, right. And generally speaking,
Yeah,
that's
it's like prove to me that you haven't opened one of those books behind you in the last week. How do you go about even doing that, right?
yeah. I mean, I guess, circumstantial evidence. I can talk about how much time I've spent sitting in this particular chair. How many times I've looked back at the bookcase, I guess. Yeah, but yeah, no, that's exactly right. I mean, that's one of the difficulties, like I said, in this particular kind of area.
It did seem
So,
that one of the sort of tenets of the Me Too movement was an idea that believe all women to the point of their word should be good enough, and we did see some problems in that, as you'd expect. And of course, there's some fairly famous incidences where there's been some fairly serious false claims. The Duke Lacrosse case comes to mind. The case in the Rolling Stone magazine comes to mind. And I
mhm.
believe, if memory serves correctly, the Mattress Girl case was essentially disproven, if memory
Yeah,
serves correctly. So
that's
a lot of these cases aren't what they purport to be.
That's actually this case actually reminded me of the mattress girl because now and just for to remind people that that the case that we're talking the mattress girl was, what university was that? Do you remember?
I want to say it was like an Ivy League.
Yeah, I wanted to say that too. Somewhere on the East
Brown?
Coast, and
I think it was Brown.
maybe I'm not sure, but there was a girl at a university in college that was for months she was carrying around her mattress with her all around campus because she was uh, basically upset because of the fact that the university wasn't charging. Oh, was it Columbia? That's what.
That
Yeah,
sounds right.
yeah, Columbia. That sounds
It
that
was
sounds
one of
correct.
them.
Yeah, that sounds correct. Columbia University. That she was carrying around her mattress and basically saying that the university needed to not charge him because they don't charge him, but they
Title
put on
IX his
a.
ass.
Yeah,
Kick him
exactly.
out of school.
Yeah, but they weren't putting on a case, and so she was basically carrying on the mattress to bring awareness to the fact that she wanted to have him uh, put in a hot seat for it.
And
So
I've covered a couple cases on my channel where universities are getting whacked for not giving enough due process for Title IX cases. So you've seen a slight uptick in that, where universities are going too far and they're discriminating against men effectively, and they're like, well, the statute reads no discrimination on the basis of sex, and you're not treating the
yeah,
men fairly. It's like, oh, we didn't think that was possible. You can't discriminate against men. It's like, I'm reading the statute right here. Yes, you can.
yeah.
It's like, yeah.
Yeah, and yeah, so the accused student was found not responsible by the Columbia Title IX hearing panel. So that sounds about right.
Okay. So
So,
that's
but
what they looked at the evidence and the conclusion they came to, which I believe was ultimately validated. As memory serves, of course, months and months later, that her story basically completely fell apart. Not that she stopped carrying the mattress even after it proved apart. She carried it into graduation, even though she was told not to, and she carried it just to make that point. So okay.
yeah, which I mean, which like I said, at least half the motivation for a lot of cases, criminal or civil, are they're the motivation is emotional, right? You want to know that you're right, know that you were harmed, hear that from somebody. So I don't know.
Yeah, give me immunity and give me indemnity, and I'll happily confess to anything that I did in the past. So that's all you really want's an apology. Well, we can arrange that, right?
Yeah,
Oh no, I
yeah.
want some more things. That's what I thought.
That's very often the case too. So anyway, we can move on to another subject if you'd like.
Yes,
I wish Nate were here. I don't know
Nate's
what happened.
Nate is bad. Nate's very bad.
No, he's not bad. He's just yeah, I don't know. He's
We'll
off
text
somewhere
him.
else. Yeah. So, but otherwise, I just realized I didn't do proper introductions. Obviously, this is Kurt with Uncivil Law. If you
Hello.
guys, and most likely everyone here watching is familiar with your channel, but if you are not, go ahead and take a look at his channel at Uncivil Law, also on YouTube. Fantastic channel, great legal analysis, goes over all kinds of
Best legal
stuff.
analysis.
I mean,
Best legal analysis.
almost best. I'm just kidding. So, okay, let's see here. Let's share this. Okay. Kim Kardashian talking about Kim Kardashian here. So most people probably know, um, she's been studying to become a lawyer. She's not in law school, but California has this funny thing where you can either go to a law school that's accredited by the ABA, or you can spend 4 years studying basically under some other lawyer that is, oh, actually, before we
You can
go
basically
into
be an
this,
apprentice.
yes, yes. But little plug for you, go watch the Capitol Riot saga if you haven't seen Kurt before. Yes, if you're interested in the January 6th Capitol riots, definitely go and check that
We
out.
found one finally where they might be not guilty.
Wow.
I know.
Okay. That's kind of surprising, actually. I'm not gonna lie.
Yeah.
So anyway, so back to Kim Kardashian. Yeah. So it's essentially an apprenticeship, like you said, Kurt, where you can study under somebody who's in good standing with the California bar, and then there's just a slightly different requirement. So normally in law school, your first year of classes, no matter where you are in the country, are going to be the same. You've got property, civil procedure, constitutional law, criminal law, et cetera, et cetera. So if you aren't taking those classes in California, basically they create this preliminary requirement that you're supposed to take what's called the baby bar. It's essentially an exam on those first year classes. And then after you pass that, then you can actually sit for the bar exam. So Kim Kardashian, it was just revealed today, I guess, yesterday, today, whatever, that she did not pass the baby bar exam. She needed a score of 560 to pass, and she received a 474. That's fairly close, I've got to say. I mean, I don't know. I haven't actually taken the baby bar.
I have no idea what those mean. Yeah, you went to California. You didn't go to school in California. You just took the California bar.
Well, but either way, I went to an ABA accredited school, so I didn't need to take the baby bar. Is it only for the non-accredited schools? Yes.
Okay, well all right. That explains a lot.
Yeah. So it's just for schools that aren't accredited by the ABA, or if somebody is doing like Kim Kardashian is, she's doing the apprenticeship sort of program. And so she said that she was really embarrassed. She spent 6 weeks straight, 10 to 12 hours a day studying, and it was so important for her to take this. As many people know, her dad was a famous lawyer. He defended O.J. Simpson in the trial against O.J. Simpson for the death of his wife, Nicole Brown Simpson, right?
Yes.
I was in like kindergarten when that happened, so I have to recall some of that.
I hate you.
Sorry. Don't worry, it'll change. Just give it time, it'll change. But so her dad was a famous attorney, very successful attorney, and I think, I don't know, what are your thoughts on Kim Kardashian becoming a lawyer or trying to become a lawyer?
I kind of was cheering for her, to be honest. I was cheering for her.
Yeah.
I was secretly cheering for her a little bit. I was like, go for it.
I am too. It's funny because it's like overwhelmingly what I see on social media, especially from a lot of other lawyers, is like a lot of people seem to be like making fun of her for it and being like, oh, good, she shouldn't become a lawyer. And I think that's really bad for the profession. I mean, not necessarily bad for the profession, but I feel like it's, number one, it's not a good look. And number two, like, lawyers would do well to welcome someone like Kim Kardashian. If she wants to spend her time working on criminal justice reform and, making the world a slightly better place for people that are serving time and maybe shouldn't be. I mean, yeah. I think that's a good thing. I think that's absolutely a good thing.
There's the whole Innocence Project and lots of organizations like it. There's definitely a need for that kind of work. So, hey, why not go for it?
Yeah.
And she has a platform and she's recognizable. So
exactly.
She can be a powerful voice. So
yeah. And she's already used it too, right? So it says here in this HuffPost article.
She managed to get Trump to grant clemency. Yeah.
Yeah. So it started with her interest in the case of Alice Johnson, a grandmother who received a life sentence for a first-time nonviolent drug offense. So yeah. So personally, I hope so. And this came out because I guess there was an episode of Keeping Up with the Kardashians that just came out yesterday or today, and she was talking about it in the episode. And so TMZ initially reported on it, and I guess they had heard that she had failed previously, but they didn't get confirmation. And so anyway, so this is obviously confirmation. But in the video, she was talking about how she had another chance coming up in the coming November. So obviously this was filmed probably last spring or last summer, and so she may have had a chance to retake it and take it again and maybe pass. So, but and on top of that, not everyone does great on taking an exam the first time around. Personally, I took the LSAT twice. I took the MPRE twice. I took the bar exam twice. So I'm not about to judge anyone.
The first time. Ooh.
Well, good for you. So yeah. So I have no issue with her failing the exam, as much as it sucks and as much as she, as much as people like to dunk on Kim Kardashian. I don't know. I'm still rooting for her. I still think this is a good thing.
The unaccredited schools are dragging the bar exam rates down, because for the ABA schools for ABA, because I was looking it up while we're talking, whether in-state or out-of-state, you have a 70+% pass rate. And then the in-state, whether it's accredited by California, not ABA accredited, mind you, but accredited by the state, or unaccredited, 25%. So it makes the numbers drop precipitously.
Yeah.
But so I don't know what the issue is here. I'm sure she was studying hard, but hey, there are people who take the bar exam once, like yours truly, and just completely ace it and are just that brilliant. Yeah. And people like Alita who less so. And you can do either one of those and you'll be great.
Yeah. No, exactly. I mean, for me, and here's the thing too, is that we don't necessarily know. Oh, hey, check it out. Nate is here. Hey, Nate.
Do we have a camera and a mic?
Yes, we have a mic.
Turntables and a microphone.
Working on camera.
No camera?
He's working on it.
Okay.
Also work on the microphone, because it sounds like you're in a tunnel.
All right. Well, he's muted for now, so he can join it. He can join in when he's ready. But I'll at least add him to the stream. But what was I saying? Oh yeah, we also have no idea what else was going on in her life. Well, not no idea. We have some idea. We all know for a fact that she was in the process of divorcing Kanye West. She's got a couple small kids at home.
That's got to be distracting.
Yeah, especially someone like Kanye West, like with the issues that he's been dealing with, right? I mean, she's alluded.
Was the California bar exam 2 years ago or something like that, where a person was giving birth while taking the bar exam?
I'm not surprised. I hadn't heard about it. But I am not surprised. I remember. Do you actually? That makes me wonder. Do you have any crazy bar exam stories from when you were taking it?
I have one minor one. It's not that big deal, but okay. So in Virginia, where I took the bar exam, they're super formal. So I don't know if this is true in any other state, but Virginia makes you take it in suit and tie. And most other states, I think you can take it in anything, but they make you wear suit and tie, like they make you wear courtroom appropriate attire. And one of the things so those proctors were really, really like hammering us. It's like, you cannot bring a cell phone in here. No cell phones. If we find a cell phone, we will report you to the bar. You'll never be allowed to take the bar ever. You'll be thrown out, blah, blah, blah. And of course, halfway through the exam, one of the proctor's phones went off, which was kind of hilarious.
That's pretty funny.
Yeah.
I remember. So
Did you have to wear suit and tie for your bar exam?
Oh, thank God, no. Thank God, no. But I remember. So I mean, everyone is super stressed during the bar exam, right? And I remember that there was the first time. Actually, this was when all the stories happened, because I remember there was one of my classmates had said that they were going to the bathroom at one point during one of the breaks or something like that, and there was one other test taker that was in the bathroom, like with a couple of her friends, and the other two were trying to convince her to stay for the rest of the exam because she was convinced that she was going into labor. That wasn't. I hadn't heard of somebody actually going into labor, but I remember hearing about that. They were just like, no, like you've got to stay. You've studied for so long, and she's like, no, I'm pretty sure I'm having a baby right now. Like I'm pretty sure this is
Hey, the
happening.
woman who had labor in the middle of the bar exam passed, so it worked for her.
Yeah. Then there was another day, I think it was like day 2, that someone had it was during the lunch period that they had been crossing the street to go and get lunch, and then they got hit by a car. And the guy literally, like, the cops came and he filed a report and this and that. And they so he had to basically convince the cops not to call an ambulance, not to call, the fire department or anything, because of the fact that he was like, I got to go back in there. I got to go back in and take a test. And so yeah, that's what happened. He went back in, and I remember thinking about it. I was like, I would have done the same thing.
Probably.
After all that time studying, like, that's such a letdown.
The other thing I remember too, because I remember one essay question from the bar exam, like, by memory, because for a couple reasons. I had only discovered the answer to the question like 2 days before the bar exam, because I was doing prep right up to the end, and in a test question I was giving to myself, I got the answer wrong, and so I was like, oh, that's really interesting. So 2 days later, it became the basis of an entire essay question. So I was like really cocky about that. And the other thing was, because the answer was different under the UCC versus common law. And the question said specifically at the end of the question, discuss this under UCC. And so I asked a couple people on the way out of the, bar exam day. It's like, oh, what did you write down? And everyone I said, oh, I talked about Baylor Bailey. I talked about Baylor Bailey. I'm like, wrong answer, but thank you for playing.
Oh, no.
The bar exam nightmares, huh? What's going on?
Hey, Nate, how are you?
I'm doing all right. How you guys doing?
Doing all right.
We're happier you're here. We missed you. I miss you. I miss you, baby.
We're being treated to Kurt karaoke again.
Yes.
Kurt karaoke is best karaoke.
So yeah, Nate, we've been talking about Kim Kardashian and how she failed the baby bar, but we're pulling for her.
Kim, if you're out there and you're watching this, first of all, hi. Second of all, I'm wishing you all the success. I believe in you. You can do it.
Yeah.
Lots of other people have failed and gone on to great careers.
Yeah.
Some fairly famous people have failed like 3 or 4 times. There's like a whole list of people who failed the California bar multiple times.
But this wasn't the bar, right? This was like the baby bar, though.
Yeah, well, same principle.
Whatever.
Yeah. It's this was the baby bar, but I would say that in some respects, I understand someone failing the baby bar even more so than the bar exam. And mind you, this is coming from someone who has taken the bar twice. I mean, I think I would understand that even more so because of the fact that in law school, really what you're learning in law school is how to think like a lawyer, right? Like, you're not actually learning the actual practice of law. You're not learning, like how to go down to the courthouse and file a case. You're not learning anything like that. You don't necessarily know how to represent clients. What you're learning is how to look at a situation and analyze it like a lawyer. And I think that somebody who isn't doing that every day in class, that they can have an uphill battle depending on whatever sort of mentorship program that they're going through or internship or, whatever. They can have a harder time making that transition, I think, by not being in a law school environment day in and day out and having sort of that pressure cooker change to their brain. I don't know. What do you think, Kurt?
I think that's right. It's interesting how much I think my brain was already well primed personally, so I don't think it really transformed me that much, but it's interesting how it gets you to think in particular ways, and you don't really notice it until someone who's outside points it out. And we were commenting, I think, about this together on Instant Message or something, how nice it is to talk to another lawyer, because you can't really have discussions about law except with another lawyer. It's because the other lawyer has all this background information and background knowledge that you can rely on.
Yeah.
And and they understand issues like nuance and word precision and not extending ideas beyond the scope of where they go and things like that.
Yeah.
So it's just real. One of the things that was been really nice about this community for me is just being able to talk to other people who speak my language.
Yeah.
And other people
Yeah.
are like, what are they talking about?
Yeah. Yeah. Which, I mean, of course, part of what we're trying to do here too is to expand that environment to other people as well, so that other
absolutely,
other people can understand this
I'm
sort
not here
of
to
language.
hide the ball. I'm not here to keep it, secret society or anything.
Otherwise, how would our channels
best.
expand?
That's right. Exactly.
Nate, were you saying something?
No, I was just agreeing with Kirk. I consider myself to be, I don't know, legal communicator, if it's the right terms to use, but my goal is always to try to make the law digestible for the normal person, for the normal man. You know what I mean?
Normies.
I think every profession has it. Like that, isn't that what Bill?
Oh, sure, absolutely, yeah, it's a problem. Every profession. I don't think it's a uniquely legal problem.
Yeah, no, I would definitely agree. So, Nate, do you have any crazy bar exam stories?
No, I know we took ours over 2 days. Well, my wife, because my wife had just given birth. I was about to say I just gave birth, but my wife just gave birth to my daughter like 2 days earlier.
Oh,
The
wow.
bar exam. So I wasn't even going to take it. Yeah, but because she had some complications too, so I wasn't even going to take it. But I was in this accelerated program. I was like a real geek in law school, so what they would allow you to do is after 2.5 years in law school, if you had above like a 3.5 3 or whatever, they put you in a program where you could actually practice law in your last semester. But to do that, you'd have to take the bar in February instead of June with your class. So I wrote to the program, my grades are good enough, and I got accepted into that program. But now, my wife giving birth and having complications, I was like, oh, now, what am I going to do? Because the semester before that was a semester of studying and everything for the bar exam, to take the bar exam. And the program is called the Pro Bono Scholar Program in New York. So I did that, and that Tuesday came along, and my mom had come up, and she was like, she was able to help out, and I went. I hadn't even studied for the test. You know how people study up until the test, so like that month before, I hadn't even studied anything. So I was actually going in cold, as cold as possible. But It was kind of freeing to me, though. Like going in cold freed me from the rigors of studying, because going in cold like that, I was just going in to really fail the test. I wasn't going in to actually pass the test. You know what I mean? It's like, I don't know, it's hard to explain, but I really didn't have any hopes of passing the test. Yeah. So I could just really write whatever I wanted to. I was giving it a good shot. It was kind of just a work through for me, because it wasn't gonna really hurt anything for me, because I didn't graduate till June anyway. So I could take over my class. So I went inside there, and I remember even one of the questions, because back then you had to do the bar exam is so easy now. Back then you had to know New York specific law for certain topics, and then the federal law for other topics.
Both hills and both ways.
So we had to learn the whole thing of New York law, and on top of that, federal law. So criminal procedure, New York federal. So we had a lot of that. So I remember, there was one question where it was actually federal law, not New York law. So I wrote the rule wrong for New York. And then at the bottom of the analysis, I was like, but all this is junk because this is New York and this is the New York rule. And then I did the whole analysis of the New York rule. And come to find out, I did it remarkably, extremely well on the test. And it was really because I just relaxed and just took it like that. I remember the second day, it took people 4 hours to do the multiple choice. I was finished in a half an hour. I was finished so quick they thought I didn't even finish the test.
Half an hour is fast. I did it in about half time. I think I did it. It was just under 2 hours for me, but I definitely did it in half time.
Listen,
but doing it in a half hour that's baller.
I was so locked in. You know how you had the first it was the first section then you go to lunch. The first section I was done in 45 minutes. I checked it twice. The second section I was so locked in, I did it in 30 minutes. When I handed the woman my paper, she said, "Good, better luck next time." And I told her, "This is the next time," and that was it. Boom.
Wow,
nice.
That's incredible. I definitely took all the time. given
But I didn't
for all of
care.
my.
I wasn't double checking answers. I didn't
Yeah.
care.
Yeah.
It's A, it's B, it's C, whatever.
That's incredible. I will say this though. I knew that I passed it. So I, like I mentioned, I took it twice, and the second time I knew that I passed it because I had the same feeling that I had the second time that I took the LSAT, which was when I handed in all my materials at the end of in California at the end of the third day, which was 6 hours each day, 3 days. Ooh, that was exhausting. That was a true mental marathon. But I remember at the end of it, I was like walking out of the room, and I was like, that was fun. I'm sad I'm not going to do that again. And so I knew that I had passed that because that was
might
exactly
be the first I've heard that particular take.
I know. It's crazy. It's weird, but I really genuinely felt that way. And I remembered feeling that way for the LSAT. And the first time I took the LSAT, I think I got like a 155. I took it in the middle of senior year finals of my last semester, and so I was like trying to get straight A's at the same time. And so that was the first one. And then the second time I took it, I got like a 168. And I remembered good. Thank you. I had that feeling though, because the first time I definitely did not. Like I was definitely thinking about so many other things that I had to do, other than that exam. But yeah, second time I took the bar exam, same.
That's really, really good score.
So.
I'll tell you another one from when I did the patent bar, because I took the patent bar. The patent bar is notorious for being worded very trickily. So they trick you in the question, or they trick you in the answer, so you have to really pay attention. So I studied for that bar exam a lot, and they also, like most bar exams, they recycle questions, and they have like some percentage of them that are new questions. But I studied for the patent bar so much that I knew the answer to like some questions was B or C because I didn't even have to read the question anymore. I literally knew what the answer was just from how it was typefaced on the page. How it looked, how the image looked on the page.
Wow.
So you just could like blur out the words, and it's like, oh, because it sits this way, I know that answer is B. I don't even have to read it anymore. So that was an interesting experience, and I finished that one in under half time too. And I didn't know when I took it that they tell you if you passed right away. I did not know that when I took it. So when I was finished and they're like, congratulations, you passed, I was like, and instantly I was like, okay, well, didn't know that was going to happen, so that was nice.
Yeah. Interesting. That's crazy. So what kind of stuff is on the patent bar exam?
It's just a lot of stuff from the manual of patent examination procedure, all the patent examination rules, and they write them to just trick you. So they'll ask you questions, and they'll have answers like, it'll be like A, B, and then like D will be like A and C or something, but neither A nor C is correct. So like you look at E and it says A or C. And because he's like, well, A or one of them must be correct because otherwise they wouldn't be asking me that. It's like, yes, they would. The answer is D. So the answer is they just make you trick stuff like that.
Yeah, yeah.
And they have like one sentence in there that kind of negates the whole thing sometimes. So you have to really pay attention. Pain in the ass.
Interesting. So, what was I gonna say here? Oh, so do you guys want to turn to a new subject?
Sure.
Okay. Well, we can talk about, do you want to talk about RBG's will, or do you want to talk about that new social media law in Florida?
Ooh, well, I don't know anything about the will yet, so why don't you tell me something?
Okay, well, I will show.
Did RBG give me money?
No, it's actually much more boring than what the headlines sort of suggest. She leaves most everything to kids and her housekeeper too. Like newsflash, lawyer actually takes care of her estate.
That seems kind of normal, around the middle.
It is absolutely 100% normal.
Then the headline I read say something that like RBG will shock you, and I'm like, I'm not shocked by that. Okay.
I think honestly the most interesting part of this is the fact that TMZ is reporting on this to begin with. I mean, we all know that RBG has kind of become her own sort of. I don't know. She's in a category of her own, right? Because like she's sort of been elevated to this pop culture status that is pretty much unprecedented for a Supreme Court justice.
At least in our time.
Yeah, yeah.
Maybe you go back in the day, you get some people like that, but yeah, not in our time.
Right.
Holmes was probably there.
Maybe. I would like to think so, especially since after all, I named my cat after him. But yeah. So RBG, she's on T-shirts and she's in memes and all kinds of stuff. So many female lawyers have the RBG dissent collar that they like to wear, or they like to reference. Basically, this is it's pretty much basic. So she has personal property that's worth about $5.5 million. No breakdown of exactly what that entails, but most of that goes to her kids, except for $40,000 in cash goes to her housekeeper, who was her housekeeper for 22 years. That's kind of nice.
This sounds like a perfectly banal, ordinary will.
Yeah,
so,
yeah. There's absolutely nothing
I feel
controversial.
She didn't leave it to the Society for Ruth Bader Ginsburg Law Studies or something. That's sad.
Yeah. So, anywho, So that's basically it. 2 minutes. Any other thoughts on that?
Nope, that was easy.
Yeah.
Ruth Bader Ginsburg has perfectly ordinary will.
Yeah. And she had, I think her husband had predeceased her, so that's pretty much what that is. Yeah, just like John O'Brien said, other than a housekeeper, isn't that literally intestate inheritance? Pretty much.
Pretty close.
Yeah, which that's one of the benefits of drawing up a will. And the thing is, one question that I do have is whether, because they're referring to a will, but sometimes people refer generally to a will/trust as just somebody's will. So I'm wondering, my curiosity was also whether this was in a will or trust. Most likely, my guess is, especially if it's worth around $6 million, she probably had it in a trust as opposed to a will.
No, there are what they call testamentary trust, right? Where the will, within the will, it institutes a trust. So that may be what you say, where somebody will say, okay, put money into a trust, and then that trust would then go on.
That's true too. So yeah. Anywho, cool stuff. Interesting.
I'm sorry. I'm really a nerd. I apologize.
No, that's why we're here, right?
You're having a rough day, but that's okay. We're here to support you in your time of need. And make fun of you, both.
Yeah, somehow those two incongruities match up in this instance.
We only roast the ones we love.
Fair. Very fair. So, anywho, you guys want to move on to the Florida law then?
Yes, let's talk about Florida, who may or may not be trying to do something right today.
What were you saying, Nate?
No, I said Florida and freedom.
Florida and freedom. So Florida law seeks to rein in large social media companies. I see multiple issues with this law. You guys wanna lay the foundation for this one?
No, I think you should lay the foundation. Or Nate wants to.
Okay, so basically, a lot of people have probably heard about this. Governor DeSantis signed a bill on Monday that seeks to punish social media platforms that remove conservative ideas from their sites, though it's not clear if it would pass constitutional muster because it might violate the First Amendment. So basically what they're saying is online social media platforms are censoring conservative voices too much. And so what the state of Florida is going to do is any social media platform that essentially censors a politician for their political beliefs or censors any Floridian for their political beliefs is going to be punished. They're going to be fined, right? So there will be a fine of $250,000 a day if they remove an account of a statewide political candidate, $25,000 a day if they remove an account of someone running for a local office. So that includes.
Yeah, so unless I'm mistaken, I thought this only extended in terms of the censorship angle to anyone who was seeking office or was a holder of office, not to all Floridians.
I was reading here somewhere. I thought it said that it also applied to Floridian residents too, but I might be wrong on that if you have heard otherwise.
Yeah, I think it was only for political speech, which it makes the First Amendment analysis a little bit interesting, I suppose.
Yeah.
Although I'm not sure which way it splices, because First Amendment law, there's different kinds of speech in the pyramid, and usually at the very top of the pyramid is political speech as the apotheosis of speech, because if you want the right to say anything at all, it's probably the right to say things about the government. But so that's probably the most important kind of speech, just a purely practical level.
Well, here, all right, the First Amendment argument I see here is obviously compelled speech, right? The government's compelling Facebook or whoever to keep these voices out. Compelled speech. And then the second issue I see is a presumption issue, right? Because the federal government is the one that regulates, Section 230, so forth. So then, there's a presumption, preemption argument that they're preempted. So I don't know. I don't see the Florida law getting off the ground, because I think it really has.
I don't see the 230 problem, but the First Amendment problem I do see. I don't see a conflict with 230, the way 230 is written.
I do.
You do?
Well,
yeah.
Right. Well, maybe I'm understanding preemption wrong. But preemption is if there's a federal law in the space that dominates the space, then a state law that either contradicts that or they fundamentally.
Well, let's pull up 230 and have a debate. How about that? We'll have a nice little legal debate between you and me.
Right. Let's see. So
we will have justice. One will be proven right. One will be proven wrong in the Thunderdome.
All right. Let's pull up section 230. You know what? While I do this boring part, I'll put just our faces on.
That's right.
Okay. Let's see.
Law.
Well, hold on. Why are we looking up Section 230? Because it wouldn't be in Section 2.
We're looking to see if there's a problem with. We're looking to see if the Florida law is in conflict with 230. Because I'm saying I don't see the conflict, and both of you are saying there's conflict. So if we pull up 230, we'll be able to see if there's a conflict.
Well, just all right. So to be clear, remember the Arizona law that started for immigration, and they were like, we can do this, and they were like, well, that law, right? It didn't conflict with the federal law. As a matter of fact, it enhanced it, right? But the fact is, the Obama argument, the government's argument, the Obama administration, was that that law was preempted by federal law because federal law was already in that space, and if federal law is already regulating that space, then some states can do something. But generally, if it's the same thing, like with immigration, then state laws don't matter, and that's what I'm saying. I think this is where that type of preemption applies here.
Well, the problem with the immigration thing was the Constitution specifically says that the federal government shall be the sole authority with respect to that issue. So it was actually unconstitutional in that case because of conflict with that particular clause.
Well, we're talking about interstate commerce here, right?
This would be whether or not Congress can do it. I'm not saying Congress can't do it, but whether Congress has done it. So whether there is a conflict with 230. So could Congress preempt the field? Sure. They could prevent the state from legislating. I don't disagree with you. But did they do it?
All right, so let's say this. So let's say Congress passes 230 giving them this exemption based on blah, 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 blah. And now a state says, we're not we're going to fine you based on, damn 230. We're going to fine you if you do X, right? Because 230 says they can't do it. Florida's saying we can do it. I think the preemption problem is there, right? Because generally they would have immunity, and that immunity is and we have the interstate commerce piece to it. So I think the interstate commerce piece gives the government the authority, but I think they preempt the field.
Yeah, no. So the supremacy clause of the Constitution is what we're referring to here, and I do agree with Nate, because the language of Section 230 is very broad, right? I mean, it provides any kind of immunity to civil liability essentially for moderating a platform, and that includes liability for constitutional claims. So that is. Let's see. I think I can probably find
how they could any more preempt the field.
Yeah. Yeah. So they. So whether or not such material is constitutionally protected. So that includes constitutional claims. So I don't see how a state can then come in and say, no, we're going to cut away at Section 230. You can't do it. You've got to do it on the federal level.
Well, here's what I think, here's the idea at least. So we don't want to impose liability on an interactive computer service for any voluntary action taken in good faith, blah, 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 otherwise objectionable. So, and then there's this clause in E3 which says nothing in this section shall be construed to prevent a state from enforcing any state law consistent with it. And of course, any inconsistent law cannot be enforced. So the question is the state law consistent or inconsistent with it? Because section E3 takes away the preemption argument. So E3 very clearly says there's not a preemption issue. States can have laws that are consistent with it.
Yeah,
so then the only question becomes, is it consistent with it? And the idea, I think, from Florida is that we are saying that this action is not in good faith, or at least that's what we're trying to do. So I think that's what they're trying to squeeze themselves into.
I think that if the state statute says says it has that good faith aspect to it, like if it says Twitter modifying political content in bad faith, or if they provide a certain mechanism for what the state determines to be bad faith, or at the very least not in good faith, then I think it would stand up to Section 230. But if it doesn't say anything about that, and it just says, any kind of moderation along political lines is bad, and we're going to fine you for it, I think that runs afoul. That's too broad under Section 230. It runs afoul of Section 230's protections. Personally, I think.
I think the question, the federal question that would just come into play, was could a company, could more or less is there a possibility that you could be in compliance with 230 but violate this federal law? And
right, that's the issue.
I'm thinking the situation. Sorry about that. I'm thinking the situation is simple and plain, right? The immunity against all civil liability is in Section 230 based on whatever criteria they have. State laws can say, okay, yes, it can. I'm assuming it can mirror the law, but now we have Florida, who's obviously saying, no, here are civil penalties. They essentially are saying you don't have that protection under 230 based on our interpretation of it. I'm thinking there may be a preemption issue, even though I understand Section 5, I believe you read, removed out the congruency laws, but they still did leave room for this conflict. And the conflict here, I would say, is the immunity of Section 230 versus the state law, because the state law is saying you lose some of that immunity based on our criteria. And then I think the second piece about First Amendment and forcing them to compelling them to have this type of speech, I think that's also an issue.
And then the other thing too, and the other thing that, and still we haven't gone to the First Amendment issues, which I think are way more interesting. There's another argument too, that 2A only extends to actions voluntarily taken. So if the state says, okay, we're not going to let you voluntarily take that act, it is now forbidden for you to volunteer to do that. So you can't voluntarily take it. So if you could, you wouldn't have any liability, but you can't. So yeah, but the First Amendment issues are real because it can compel speech or anything. So let me just put it this way. I don't think the 230 conflict is the principal issue. I think the First Amendment issues are much more interesting.
I mean, I think both are issues in this case, to be totally honest.
I could be wrong, legal. I could be wrong, legal bites. Or Lita. I could be wrong here. I don't think it's frivolous to argue the point.
Yeah.
So, if we want to take opposite sides, and you can take the anti-Florida side, I'll take pro-Florida. I'll be Florida man.
I'm not anti-Florida. I like Florida. I have I've got some good friends and family that live in Florida.
Why is it legal? Gators.
So yeah. But yeah, that's about that subject.
On the First Amendment issues, because I think we've giving him a little bit of a short shift. There's some real problems here with compelled speech, to say that you are required to host speech that you do not want to host on your platform. It seems like compelled speech. Now, the only sort of argument I can kind of see against it is with some fairness doctrine stuff, but even the fairness doctrine stuff dealt with public airwaves and the idea that the public airwaves were a limited resource, which they are. So there's not enough space for everyone. So because of that issue, you might be compelled to carry both sides of something. Now, they got rid of the doctrine in 86, but I'm just saying from a constitutional standpoint, because it was upheld by the Supreme Court. So I don't think that would work here, because there's essentially unlimited space. in the internet era, but yeah, the First Amendment arguments are much more problematic because you're making social media content host stuff they don't want to host. So, yeah. Specifically, it points out on specifically on the views that those things host. That's exactly the problem. It's like we don't like their views, so that seems problematic.
Yeah.
So yeah.
I mean, I wonder if. I mean, we've talked about it before about how Justice Thomas was saying that he was considering the possibility that maybe social media platforms, the big ones, should be treated as common carriers. So that would probably change this sort of analysis, right?
And they were common carriers under Bush, and then Obama changed it, right? Yeah, something like that. So they tried for a little while.
Yeah.
That was what the whole thing against with the free speech issues with everyone turning their web pages black was over that issue, and way back a couple years ago.
Wait, people turning their web pages black?
Well, like for one day, they were all protesting for like
I
a
mean,
day about the common carrier stuff.
Oh, okay. Oh, interesting. I don't remember that. I do remember after George Floyd, people on social media were turning their, or they were adding a black Instagram image. So, but interesting. I don't know. We'll see. We'll see what happens with this. Nate, do you have any other thoughts on the issue?
No, I'm in agreement with that both of you a little bit. I think both issues are live, but if I had to go on a court with only one of them, I would probably go in with the First Amendment argument because I do think it's a little more cut and dry. It's an easier argument to make than the preemption argument, but I still think they both are winners. So,
yeah, I mean that is true. That generally speaking, a First Amendment argument is usually going to be it's going to have more heft than most other legal arguments in any kind of a case, whether it's religion or free speech. Usually First Amendment is going to be a pretty hefty decider.
And I'm pretty strong to a First Amendment, not quite in absolutist territory, but I take it pretty seriously. So the First Amendment problems are really, really serious.
Yeah, no, I definitely agree with that. Definitely agree with that. So, yeah. Any other thoughts? Cool. Well, I think that probably does it, unless we want to talk about Epic versus Apple. That was the case that happened recently, and I mean, trial just ended this week, but there's no.
We're all waiting for the opinion to tell us.
Yeah, which will be August.
The judge is going to spend a little bit more time with that than his average opinion. He has some more complex thoughts he'd like to share.
Well, it's interesting because the way that she was sort of describing or providing a metaphor for it was that basically during trial they started off with a box and each side was putting in a bunch of puzzle pieces and just tossing them into the box, and then she's like, now it's my job to put those puzzle pieces together. There might be a couple pieces that are missing here and there might be some extra ones that aren't relevant. She's like, but I've got to put them together and see what picture comes out. She's like, it's going to take me a while. And that, I feel like that was a pretty good metaphor for the situation.
Maybe if you shake the box really hard, they'll randomly assemble into the correct picture.
Oh no, she's got to parse through thousands of pages of testimony now. I don't envy her job right now. I really don't.
Oh yeah, no, I agree completely. It's going to be it's really, really challenging. From a purely legal perspective, though, the challenge, well, as you said to me when we were off, when we were talking beforehand, the issue is what is the market? And how do you define the market? And you can define the market at multiple different levels of abstraction. Is the market smartphones? Is the market the computer games? Is the market app stores? Is the market any number of levels of it? It's, I think, a little bit more helpful to describe it in real world terms when you can think about what the relevant market is. So you have a store, let's say in a mall. So what is the relevant level? Is it the individual store? Is it like the floor? Is it the mall? Is it a series of malls, the entire town, state?
Is it different? So is it different types of stores that sell the same kind of thing?
Exactly. It's like multiple levels of abstraction. So how do you define the right level of abstraction to say, well, these are or not the same? But I think I think that you have a really tough time, or at least I'm not seeing it. And if someone else sees it and the judge sees it and they can write a brilliant opinion, that'll be great. But I'm not seeing how you can say that the Apple walled garden is improper without really attacking other walled gardens, the most obvious being for game consoles like the Xbox or PS5 or something. So if she can figure out a way to slice that, then okay, because I haven't figured it out yet.
Yeah, no, that I mean, I think that's going to be kind of crucial. I think that's what a lot of people are. That's one of the biggest questions on a lot of people's minds. And yeah, so I don't know. That'll be a really interesting question. But I think one issue is, I mean, game consoles are just they're different from iPhones. They're different in the ways that they're used. They're different in the ways that they factor into people's lives. You know, a game console it has one place that it sits, you know, in someone's home. Generally speaking, it's usually by the TV. You don't take it with you most places unless you're.
Hey man, I was OG Game Boy. You know, I took to take that thing with me everywhere, man.
Well, yeah, okay. So that's fair. So a Nintendo Switch is obviously very portable. I mean, that's half the reason why I even have one, is because my husband wanted us to be able to travel together with our Nintendo Switches and, you know, play together. But for the most part, I think when it comes to most game consoles, that usually what we're thinking about is Xbox and Sony, or Xbox and PlayStation. I mean, those are, you know, you can use them for other apps, like you can use them to watch Netflix and all that kind of stuff. But generally speaking, you're still relatively limited on what you can use those for. Whereas for an iPhone, I mean, you use it for everything. You use it for financial transactions. You use it for, you know, learning how to do yoga, for meditating, for, you know, sometimes, you know, you can take master classes off of your phone. There's all kinds of.
You could be watching this stream right now on your phone.
A lot of people probably are. I hope they are. And so I think that the versatility of the iPhone and the way that it factors, you know, the iPhone and you know, generally speaking, the smartphone, you know, the Android as well. I think the way that they factor into our lives, I think that there's a lot there to talk about in terms of how that's different from game consoles. Because in order to switch from one game console to another, you know, you can make the switch. You can own more than one game console. You can own an Xbox and a PlayStation and have them both at the same time. Obviously, that's an expensive way to go about it, but generally speaking, people don't have an iPhone and an Android. You usually pick one or the other.
I don't know how true that is necessarily. I don't know what the U.S. government is doing these days. But, you know, everyone used to be issued a BlackBerry so that everyone had their personal phone and a BlackBerry. So I don't know if they're still using BlackBerries or whatever, but it wouldn't be absurd for someone to have a work phone from one device and a personal phone for another device.
Yeah, but that's assuming that someone is actually given a work phone. You know, that's not there are plenty of people out there that don't.
Drug dealers? They need mobile phones for different kinds of clients?
They need their burner phones.
Yeah. Burner phones. The burner phones are real, and we have to destroy them every time, a la Breaking Bad. So we're going to use old school flip phones because they're the best, apparently.
Yeah. So I don't know. I mean, I think there's enough there to at least have a conversation about the difference between a smartphone and a game console, just as an example. And I think personally that the market here, I think that the market here is the iOS app store. It's the overall app market. It's not just gaming, because the thing is that the reason why people are focusing on gaming consoles is because this was triggered by Fortnite, right? Which obviously is a game. It's a mobile game. It's also on consoles, et cetera, et cetera. And so people, I think, have naturally characterized this as a game industry issue. But if you read the complaint, if you read, you know, what everything that Epic has put out there, they're talking about the apps, all apps in general. They're not just talking about gaming apps. So I think that to say that, you know, the what is it, 30% fee that Apple charges is an industry standard. That's maybe an industry standard across the gaming industry, but there are plenty of apps that they're talking about that have nothing to do with the gaming industry. So I think it's a bit wider than that. But I mean, the court might disagree. Obviously, court can always disagree with me.
That's right. Yeah, and that's how we know they're wrong.
Of course. So I don't know. Those are my thoughts on it. I know Rick Hogue has been doing a ton on this.
Oh yeah, he's been the man championing this thing. He's been following it from play to play. So
yeah. I mean, I wanted to put out content on it, but it's like drinking from a fire hose. So I just was like, I'll let Rick handle it. He's doing a great job. So, but
let him
yeah.
figure it out. That's right. Yeah.
So anyway, well, I think that pretty much about does it. Unfortunately, it looks like we lost Nate earlier. I don't know what happened there.
Disappointing.
But yeah,
we love you, Nate, wherever you are out there.
Yeah, we'll see you next time. So next week we're on Nate's channel, I think, right? Or are we on yours again?
Or we would be on my channel.
Oh crap! Now I can't remember. Usually I'm at least keeping track of
one of them.
We're either on.
We'll figure it out.
Or Nate's. So yeah, we'll figure that out. But yeah, otherwise, if you guys are unfamiliar with Uncivil Law or Nate the Lawyer, go check out their channels. Obviously, always be sure to like the video if you enjoyed the stream, if you enjoyed our conversations, and like, subscribe, and share all the fun YouTube-y stuff. So anyway, and then otherwise, we will catch you guys later. See you in the next video. Bye.